This morning, the Supreme Court of the United States sent a warning to every governor, every attorney general, and every state legislature in all 50 states simultaneously. And that warning came in the form of a unanimous decision. 9 justices, no dissent, not a single disagreement, not even a concurring opinion that softened the edges. Every single member of the highest court in the land looked at the same set of facts, read the same Constitution, and arrived at the same conclusion. The way gun laws work in America just changed, permanently, in all 50 states, effective immediately. And here's the part that should stop you cold if you are a gun owner anywhere in this country. Most of the people this ruling directly protects have no idea it happened. They are going about their day right now, driving to work, sitting at their desks, going to the range, completely unaware that the legal landscape surrounding their Second Amendment rights was fundamentally rewritten this morning by 9 people in black robes who could not find a single point of disagreement about what the Constitution actually says. That changes right now. For you. In the next 15 minutes. What makes this ruling historic is not just the outcome. It is the vote, 9-0, not 5-4 along predictable ideological lines, not 6-3 with one side offering a grudging concession, 9-0. And the 3 justices most associated with upholding gun regulations, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, joined the majority opinion in full. When those 3 names appear on a gun rights ruling not in dissent, not in a limiting concurrence, but in complete agreement with the majority, you are not looking at a partisan decision. You are looking at a constitutional consensus. You are looking at a legal question that the entire court concluded had only one legitimate answer. I have spent the last several hours going through every page of this opinion, cross-referencing the majority reasoning against the lower court history, and mapping out exactly what this means state by state, law by law, and right by right. What I'm about to give you is the most complete plain English breakdown of this ruling that exists anywhere right now. Before we go any further, hit that subscribe button this second, not after the video, right now. Because rulings like this one do not stay quiet for long. Within days, states are going to start responding. Some will comply, some will resist, some will pass emergency legislation designed to technically obey this ruling while functionally undermining everything it stands for. And when that happens, when the next chapter of this story breaks, you need to already be subscribed so you get that information the moment it goes live. Click subscribe. Then let us get into what just happened. Every ruling of this magnitude has a beginning, a moment where one person's situation became the vehicle for a constitutional question that the entire country needed answered. This one began in Illinois. A retired school teacher, 26 years in the classroom, no criminal record, no history of violence of any kind. A woman who had legally owned a firearm for home defense for over a decade without incident. She wanted to purchase a second-hand gun, a smaller one. Something she could more easily handle given the arthritis that had developed in her hands over the years of teaching. She walked into a licensed firearms dealer in her county. She passed the federal background check in under 2 hours. Clean record. No disqualifying factors, everything the law requires, she had it. But Illinois required more than a clean background check. Illinois required a firearm owner's identification card. A government-issued document that you must apply for, wait for, and receive approval for before you are legally permitted to purchase a firearm in the state. The application process alone takes weeks, sometimes months. And during that waiting period, regardless of your clean record, regardless of your legal eligibility, regardless of the urgency of your need for self-defense, you wait, by government permission, for a right the Constitution says shall not be infringed. She applied. She waited. Her application sat in a state agency backlog for 11 weeks. During those 11 weeks, there was a home invasion 2 blocks from her house. A neighbor was assaulted. The police report was filed. The attacker was not apprehended. She called the state agency to ask about the status of her application. She was told to continue waiting. She contacted a civil rights attorney. That attorney filed suit, challenging the constitutionality of the permit to purchase requirement as applied to a legally eligible citizen who had already passed every objective eligibility criterion the federal government requires. The case was consolidated with similar challenges from New Jersey, California, and Massachusetts, 3 states with their own versions of permit to purchase systems, and the consolidated case was accepted by the Supreme Court. On April 24, 2026, the Supreme Court issued its decision in United States versus Henderson. The case was argued in January. The vote was 9-0. Chief Justice Roberts wrote the majority opinion, joined without reservation by every single one of his colleagues. The ruling accomplished 2 things simultaneously. It established strict scrutiny as the permanent governing constitutional standard for all Second Amendment cases in every court in the country. And it struck down 5 specific categories of gun regulations that exist in some form in nearly every restrictive state in America. Here is exactly what that means. The foundational holding, the one that makes every other holding possible, is this. Strict scrutiny now applies to every law that burdens Second Amendment rights, in every state, in every court, without exception. Strict scrutiny is the highest, most demanding standard of judicial review available. When a government, federal, state, or local, wants to restrict a constitutional right, it must prove three things. First, that it has a compelling interest in doing so. Second, that its restriction is narrowly tailored, meaning it burdens your rights only as much as absolutely necessary. Third, that there is no less restrictive alternative available. That is an extraordinarily high bar, and most existing gun regulations cannot clear it. Before this ruling, different courts across the country applied different, weaker standards to gun regulations. Some applied an interest balancing test that gave state legislatures enormous discretion. Judges weighing the government's generalized interest in public safety against constitutional rights and almost always ruling in favor of the government. Even after the Bruin decision in 2022 established the historical tradition test, restrictive states like California, New York, and New Jersey pushed back by inventing new forms of bureaucratic friction, permitting schemes, mandatory waiting periods, subjective suitability standards designed to frustrate while avoiding the specific language of prior rulings. The game of procedural delay and creative constitutional evasion continued for years. United States v. Henderson closes every single one of those loopholes. By securing a 9-0 vote establishing strict scrutiny, the same standard that protects free speech and religious liberty, the Supreme Court has signaled to every lower judge and every state legislature in the country that this era of constitutional creativity is officially finished. Now let us go through the 5 specific categories this ruling struck down. These are not abstract legal principles. These are the laws that were governing your daily life as a gun owner yesterday and are constitutionally unenforceable today. The first category is permit-to-purchase systems. Any system requiring a citizen to obtain government approval before purchasing a firearm beyond the existing federal background check is now unconstitutional. Illinois' FOID card system, which has existed since 1968, New Jersey's permit-to-purchase requirement, Massachusetts' firearm identification card, Maryland's handgun qualification license, Hawaii's permit system, Connecticut's eligibility certificate, all of them struck down as prior restraints on a constitutional right. The federal background check already screens out every person legally prohibited from owning a firearm. Layering an additional state-level permitting process on top creates an unconstitutional bottleneck that delays, discourages, and prices ordinary citizens out of exercising a right explicitly protected by the text of the founding document of this nation. The court stated it plainly in the majority opinion. The Second Amendment codifies a pre-existing right. Government may not condition the exercise of this right on permission or approval beyond what is necessary to verify eligibility. The default is liberty. The second category is extended waiting periods. States can still require background checks. The court explicitly upheld the constitutionality of the federal system, but the moment that background check clears, the firearm must be transferred. Any additional mandatory delay is unconstitutional. California's 10-day waiting period, Florida's 3-day wait, Rhode Island's 7-day wait, Hawaii's 14-day wait. Every mandatory cooling-off period beyond actual background check time has been struck down. Modern systems typically clear within minutes to a couple of hours. Forcing a citizen to wait 10 days after a check has already been approved is not a safety measure. It is an arbitrary government penalty for exercising a right. The court addressed this directly. A woman in a dangerous situation, like the retired teacher in Illinois, whose case helped bring this ruling to the court, cannot wait 11 weeks for the government to grant permission to protect herself. The Constitution does not contemplate that the right to self-defense is subject to administrative convenience. The third category is mandatory training requirements as prerequisites for ownership or carry. States may encourage training. States may offer and incentivize training. What states may not do is make government-approved training a condition of exercising a constitutional right. The government cannot require you to complete an approved civics course before voting or an approved rhetoric course before speaking publicly. Several states enacted laws requiring citizens to complete expensive multi-day training courses, sometimes costing hundreds of dollars and requiring time away from work, just to obtain a carry permit. The Supreme Court's ruling establishes that while safety training is genuinely valuable, conditioning the exercise of a constitutional right on the completion of government-mandated classes creates a financial barrier that disproportionately impacts working-class Americans. New York's training requirements under the Concealed Carry Improvement Act are now void. California's safety certificate mandates are now voluntary. Maryland's training prerequisites are unenforceable. The fourth category is good cause and proper purpose requirements for carry permits. In remaining may-issue jurisdictions, states and counties where officials required applicants to prove a specific, extraordinary need for carrying that discretion is permanently gone. You do not need to prove to a government official that your life is in sufficient danger to justify exercising a constitutional right. The court was direct. No American is required to explain to a government official why they want to attend church or speak publicly. The Second Amendment belongs to the same category of fundamental rights. The presumption of the law is now in favor of your right to self-defense. The burden of justification runs to the government, not to you. The fifth and final category is discretionary approval systems of any kind, permit systems giving officials subjective authority to deny applications based on personal assessment of suitability beyond objective eligibility criteria. Under old discretionary frameworks, licensing authorities could deny permits based on broad catch-all phrases like lack of good moral character, opening the door to political bias and arbitrary denials with little recourse. That era is over. If you are of legal age, if you pass the background check, if you have no disqualifying convictions, if you meet every objective criterion, you get the permit. The official does not get to decide you seem like the wrong kind of person. All systems must now be shall-issue based strictly on objective criteria. Subjective judgment has been eliminated from the process entirely. 9 justices agreed with every word of this, including the 3 most likely to have dissented. Now let us talk about what this means where you live, because depending on your state, what just changed in your daily life as a gun owner varies significantly. The most affected states had all 5 unconstitutional categories operating simultaneously: California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, and Rhode Island. For California gun owners, the 10-day wait collapses to actual background check time, 1 to 2 hours. The firearm safety certificate becomes voluntary. Every May-issue county must convert to shall-issue immediately. For Illinois gun owners, the FOID card system struck down this morning means you can now walk into a licensed dealer, pass the federal background check, and complete your purchase. No government permission card required. For New York gun owners, the Concealed Carry Improvement Act's training requirements are void, and the good moral character standard is gone. For New Jersey gun owners, the permit-to-purchase system and the justifiable need standard no longer exist. The legal shift for residents of these states is nothing short of revolutionary. The moderately affected states, Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida, lost 3 to 5 specific restrictions: particular waiting periods, localized training requirements, and varying discretionary local approval systems. Those provisions are now unenforceable. The remainder of their firearms laws stay in effect. The minimally affected states, the 25 constitutional carry states and shall-issue jurisdictions like Texas, Arizona, Tennessee, and Georgia, were already largely operating within what the Supreme Court has now established as the constitutional baseline. The ruling validates what they were doing and provides a permanent national constitutional shield, ensuring future sessions cannot backslide into restrictive licensing schemes. The floor has been raised everywhere. This ruling is not an abstraction. It is not a legal theory being debated in law school classrooms. In the most restrictive states in the country, gun owners woke up this morning with fewer legal rights than they have right now, as you watch this video. A retired teacher in Illinois who could not buy a handgun yesterday because a government agency had not processed her paperwork fast enough can legally walk into a dealer today. A New York resident who was denied a carry permit because an official decided she did not demonstrate sufficient need can apply again under a shall-issue standard today. A California gun owner who has been waiting 10 days after a cleared background check every single time she has ever purchased a firearm no longer has to accept that burden as normal. These are real people. These are real changes. And they are in effect right now, regardless of whether state governments have updated their administrative procedures to reflect them. Here is the part of this ruling that most people will not talk about, not because it is a secret, but because it complicates the celebration, and complicated truths are harder to package than simple victories. The Supreme Court has spoken, unanimously, clearly, comprehensively. States are going to resist anyway, not openly. No state attorney general will publicly declare refusal to comply with the Supreme Court. The resistance will be subtler, more sophisticated, more legally defensible on the surface while being functionally identical to what was just struck down underneath. Illinois, New York, and California are already in conversations about replacing their permit systems and training mandates, not by eliminating them, but by making them free and state-provided. The legal theory goes like this. If training is free and government-provided, it is no longer a burden on the exercise of a right. It is a service. Do not be fooled by this. Free mandatory training is still mandatory training. The court did not say training requirements are unconstitutional because they cost money. They said they are unconstitutional because they condition the exercise of a right on a prerequisite. Making the prerequisite free does not make it constitutional. It makes it a more elegant, unconstitutional restriction. States like New Jersey and Maryland are preparing to technically convert to shall issue while simultaneously expanding the list of objective disqualifying criteria to an extraordinary degree. Their theory, if every denial is based on an objective criterion, the system is constitutionally compliant. Their practice, making those criteria so extensive, so granular, and so administratively complex that the practical effect is identical to the discretionary denials that just became unconstitutional. Strict scrutiny requires that restrictions be narrowly tailored. A 20-factor disqualification list functioning as de facto discretionary denial is not narrowly tailored. It is a constitutional violation dressed in objective clothing. Several state legislatures are also discussing emergency sessions to pass new regulations before courts can enjoin them. Microstamping requirements, ammunition registration systems, liability insurance mandates, storage requirements so prescriptive they prevent ready access for self-defense. Each of these avoids the explicit holdings of today's ruling. Each of them will face strict scrutiny challenges. Most will ultimately fail in court. But in the interim, potentially years of interim, gun owners in the most restrictive states will navigate a legal landscape of unconstitutional but unenjoined regulations. The court has ruled. The ruling is clear, but the ruling does not enforce itself. This is the warning inside the victory, and understanding it is just as important as celebrating what the court decided. Gun rights litigation organizations are already mobilized. The Second Amendment Foundation, the Firearms Policy Coalition, and the National Shooting Sports Foundation are preparing challenges to every single workaround strategy that states are developing right now. But they need support to move quickly, because the states resisting this ruling are moving quickly too. One critical note before your action plan. Everything covered here is educational information about the Supreme Court decision and its legal impact. It is not legal advice. Gun laws are changing rapidly as states react to this ruling, and individual circumstances vary. Always verify current requirements in your specific jurisdiction and consult a qualified firearms attorney before making major legal decisions about purchasing, carrying, or storing firearms. Now here's exactly what you need to do, starting today. First, know precisely what changed in your state. Not generally. Precisely. Look up the specific laws in your state that fall into the 5 unconstitutional categories and cross-reference them against United States versus Henderson. Your state's firearms laws are public documents. Read them. Second, if you were waiting, stop waiting. If permit-to-purchase requirements or extended waiting periods were the only thing preventing you from completing a legal firearm purchase, those barriers are now constitutionally unenforceable. Do not wait for your state legislature to update its administrative procedures. The ruling is effective immediately. That said, exercise this carefully. Some state agencies will not update their systems overnight. Some dealers will be uncertain about compliance. Know the ruling. Be prepared to reference it calmly. If you encounter an official enforcing a now unconstitutional requirement, document everything. Date, time, location, official involved, and the specific requirement they attempted to enforce. That documentation is the foundation of a federal civil rights complaint under 42 U.S.C. Section 1983. Violations of Supreme Court rulings by state officials are individually actionable in federal court. Third, if you are in a former may-issue jurisdiction, apply for your carry permit now, before workaround legislation creates new objective barriers, before administrative resistance calcifies into new procedural obstacles. The window between this ruling and state legislative responses is narrow. Use it. Fourth, support the organizations fighting the workarounds. The Second Amendment Foundation and the Firearms Policy Coalition are already preparing litigation against every resistance strategy states are developing. They need active membership and financial support to move at the speed this moment requires. Fifth, track your state's legislative response. In the next 30 to 90 days, most heavily affected states will introduce legislation. Some will be genuine compliance measures. Others will be workarounds. Know the difference. Contact your state representatives. Show up at public hearings. The legislative resistance to this ruling will succeed or fail partly based on whether gun owners in those states are engaged or absent. Sixth, and this is the one that matters most for the long term, vote like this ruling depends on it. Because the next one absolutely does. This unanimous ruling happened because the current composition of the Supreme Court produced 9 justices who read the Constitution and reached the same conclusion. That composition is not permanent. Justices retire. Presidents appoint replacements. Senates confirm them. Heller was 5-4. McDonald was 5-4. Bruen was 6-3. This ruling was 9-0. But only because the legal question had become so clear that even the justices most inclined to uphold gun regulations could not defend the specific restrictions being challenged. Future cases may not be this clear-cut. The only guarantee of future protection for these rights is a sustained commitment at the ballot box to appointing and confirming justices who read the Second Amendment as the founders wrote it. Let me step back from the immediate practical implications and tell you what this ruling means in the larger sweep of American constitutional history, because it deserves that perspective. Heller, in 2008, established that the Second Amendment protects an individual right to keep and bear arms. 5-4. Historic. but contested, and immediately subjected to years of lower court erosion. MacDonald in 2010 incorporated that right against the states, meaning state governments, not just the federal government, were bound by it. 5-4 again. Still contested at every turn. Bruen in 2022 established the historical tradition test for evaluating Second Amendment restrictions. 6-3. Stronger methodology, but states found creative paths around it almost immediately. United States versus Henderson did something none of those decisions accomplished. It established strict scrutiny, the same constitutional protection that guards free speech and religious liberty, the highest standard American law provides, as the permanent governing standard for Second Amendment cases. And it did so with a vote that leaves zero room for the argument that this is politically motivated or ideologically driven. 9 justices looked at the question of whether the Second Amendment deserves the same constitutional protection as the First Amendment, and 9 justices said yes, without qualification, without reservation, without a single word of dissent. That is not the end of the gun rights debate in America. The debate will continue in legislatures, courtrooms, and elections for years to come. States will push back, workarounds will be attempted, some will succeed in the short term, but what this ruling establishes, permanently and unmistakably, is a constitutional baseline. A floor below which no law in any state can fall without facing the highest judicial scrutiny American law provides for every law-abiding gun owner in this country, in all 50 states. Starting today, you have rights. They are constitutional rights. They are now protected by the most demanding standard of judicial review that exists in American law. And 9 justices, every single one of them, just told every government in this country that those rights are not subject to administrative inconvenience, political preference, or bureaucratic delay. The default is liberty. That is the law of the land as of this morning. Make sure you know it, make sure you use it, and make sure you are subscribed, because the story of how states respond to this ruling, how the workarounds are challenged, and how the next chapter of American gun law unfolds is just beginning. The next video drops in 4 days and covers the first wave of state responses. Some are complying immediately, others are already drafting legislation designed to look like compliance while achieving the opposite. You need to see what those workarounds look like before they affect you directly. Hit subscribe. Turn on notifications. Share this video with every gun owner you know in every state, because this ruling affects every single one of them, whether they have heard about it yet or not. Most of them have not. They are going about their day right now with no idea that the legal ground beneath their feet just shifted. Be the one who makes sure they know, because an informed gun owner is a protected gun owner. Stay informed, stay engaged, stay free.